Welcome to our new video on immigration here in New Zealand, brought to you by McVeigh Fleming Lawyers. Now, I am Arran Hunt, one of the partners here, and I head up the immigration team. Character waivers are often that final step that migrants must get over to get their visa. Today we'll be looking at what a character issue is, when a waiver might be required, with a focus on residence visa applications. This video is not going to tell you how to handle it yourself. Now, responding to a character issue is something in which we strongly recommend that you get expert advice with. This video is not legal advice, it's just our commentary on immigration here in New Zealand. If you do want legal advice on this or any other matter, please get in contact with us via the email in the description down below or via our website, mcveighfleming.co.nz. Now, why are we covering this topic now? Well, last week Immigration New Zealand released an updated set of rules on the handling of character issues for residence applications. Now, this is called Amended Circular 202326, being the 26th amendment to the rules that have been released in 2023. And you can see a few of the pages here on the screen. There is 44 pages all up in total. Now, some of the pages will contain some minor tweaks to what the rules are. A number do contain a number of very large changes to the rules. And we're going to cover a couple of these in this video, but we will put a link through to the full set of changes here. You see the yellow is actually where there's a change taking place. On the description down below, you can click on there to see the link. These won't appear in the operational manual just yet. They will appear in the next couple of weeks in the actual operational final set of rules, but we'll set a link to the amendment circular in the description down below. You will often see references to A4 or A5 if you look at the immigration instructions, or if you get correspondence back from Immigration New Zealand themselves. These are the medical A4 and character A5 requirements for all of these applications. Now, under A5, immigration is looking to people who may have character flaws, and they do so to try to seek to protect New Zealand from those who may cause it harms, as well as looking at the integrity of the immigration system itself. Now, looking at the new rules, we can see that in A525.5, the factors that give rise to a character issue. So these are what will raise an immigration a character issue on any of your applications for residence. First, there's the factors around convictions, and these apply for convictions in any country. So you've got convictions at any time against the immigration, citizenship or passport laws of any country, convictions at any time involving prohibited drugs, convictions at any time involving dishonesty, convictions at any time involving any offence of a sexual nature, conviction at any time for which they were sentenced to a term of imprisonment, conviction in any country at the time the person was in New Zealand where they were convicted of an offence where the court had the option to imprison them for 3 months or more, even if the court didn't take that option. Conviction at any time for any conviction involving violence, and conviction at any time in the 5 prior years to the application being submitted, so the application date going back 5 years, or while the application is being processed for driving while drunk or having consumed drugs. Now, it's obvious why convictions for violence or sexual offences are on the list, as well as those for who have been imprisoned. Those for dishonesty or breaches of immigration, citizenship or passport laws are there, as it is often a way to show that the applicants have previously been willing to lie for their own gain, especially when it comes to immigration, so they may do so again. Onto this, we add those who have made false or misleading statements or withheld information during the application or previous applications. This is why we always take an approach of honesty with Immigration New Zealand. If you have an advisor who is encouraging you not to be honest with Immigration New Zealand, then you need to talk to us, as that is a very dangerous road to go down. We'll look actually at the false and misleading information in more depth later in this video. Next, we have notifying Immigration New Zealand about material changes in circumstance. This does not mean telling them about everything that occurs, but instead looking at changes in circumstances that may actually impact the decision that they're going to make or lead to them having to ask you more questions. For example, a job change is something that may impact a skilled migrant application because your employment is the fact that you are applying for the visa under, but it wouldn't be effective for someone who's applying for a partnership residence visa as their employment is not a factor in the application itself. For example, another example is that a breakup in a relationship of a partnership-based visa would definitely be a change in circumstance that should be told to immigration, and that would actually lead to the application probably having to be withdrawn. Next, we have a separate note about expressions of interest, or EOIs as they're often called. Now, we'll see EOIs mostly for skilled migrant residence applications, but also for other things like parent residence visas, entrepreneur visas, and investment visas. This is listed separately on here for two reasons. Now, first, the EOI is not an application. So any reference to applications made in the instructions do not apply to an expression of interest, because it is exactly that. It's an expression of interest in the hope to apply to make an application. The second reason we'll cover when we look a bit more at the false misleading information later in this video. Next, we have an exclusion for people who have been pushing hate speech of any kind. We now move to point E. Now, this is to clarify that if a previous application determined that information provided was not a character issue, then immigration should not see it as a character issue in a later application. However, this does not mean that a character waiver provided in an early application means that there is no character issue. We're going to cover the process in a moment. F clarifies that false or misleading information provided by someone under 18 will not be held against them in later applications. G does the same sort of thing for partners or dependent children who are included in an application but who are not the person that the false or misleading information was related to. So they're not going to be held against you if it was provided about somebody else, but of course it's always in the details. While Immigration New Zealand can add steps to the default process, usually doing so to try to help an applicant fix the situation they have created for themselves, there are generally a few base steps that Immigration New Zealand will always go through when you are dealing with a character issue. First, the officer looking at the application may see the issue, or they may see notes on the applicant's file from a previous application, or perhaps an alert on the file about the issue. They'll look into this as part of their assessment. They may seek the advice from more experienced staff or from third parties as to whether there is a character issue here. If they believe that there may be a character issue, then they will write to the applicant or to their lawyer or advisor to raise that there may be a character issue. They should not have at this point decided that there is one, so they're giving the applicant a chance to provide a response as to why there perhaps isn't a character issue. Now, in most cases there is at this point, but sometimes it may be down to perhaps an error in their records or a police certificate that may show a court appearance but may not show the outcome that may have been a discharge or no ongoing issues. It's at this point where we strongly advise you to contact us if you haven't done so already. We may be able to stop the character issue at this point with references to the many of the hundreds of IPT decisions that there are on character issues, which we have gone through. We can also start preparing for the rest of the process. Now, either way, once they receive your response, or if they don't receive a response from you within the period they give, they will then determine if there is a character issue. If they believe that there is, then they will then write to you to allow you to seek a character waiver. And we assist many clients with character waivers. Now, once you provide a character waiver request, or if you don't provide one within the time they allow, your file will go into a queue to be assessed by a senior officer who is not familiar with your application. Now, it may take some time, possibly from weeks or even months, for it to be reviewed and to go through that process. The officer will be looking at the situation, looking at the character waiver request, and if one has been provided, and look at the factors that appear here in A52510. Being some of the factors that the officer should consider. Now, however, this is not the total possible factors, and would look at a number of other factors that could impact a waiver request that we have learned from our experience. Now, if the waiver is given, then as long as the other requirements for the application are met, the visa can be granted. If the waiver is refused, then the character issue means that the visa must be declined. At that point, if it was declined, you would need to start looking at an appeal to the IPT or a judicial review. A complaint can be made, but only if INZ have failed to follow the process, which Usually they have followed the process, and when it comes down to character, it is down to their assessment of the character rather than them not following the process. So a complaint generally won't be successful in most situations for this area. So we'd be looking at IPT appeals most likely. False or misleading statements are where information has been provided to Immigration New Zealand and it was, as the title says, false or misleading. Now, you'd think that we have the obvious ones like someone's forged the document or they provided some fake bank statements, and that is quite clearly false or misleading statements. But it goes further than that. Simple things such as saying no to the question, do you have previous visa declines anywhere in another country, when actually you should have said yes. That is a false or misleading statement that has been made to immigration. We also see people who have made applications where they've forgotten to mention something. Well, I think the word forgot is probably generous. They deliberately have not mentioned something such as they've left a child off the application because that child would not be eligible due to health conditions. Now, they'll apply for residency, not mentioning the child, and in doing so they've made a false or misleading statement by forgetting or by failing to provide that child's information. These are all false and misleading statements under the rules. Now, under the new A525.7, they make it very clear that intention has no factor in determining if a character issue has occurred. If false or misleading information was provided or information was missed that should have been provided, then there is a character issue. Now, while intention has no part in determining if there is a character issue, it can play a part in determining whether a character waiver should be granted. And an immigration lawyer can help you with that by knowing how to properly apply legislation and look at previous IPT decisions to help you around that, to show perhaps whether there was no intention. However, as previously mentioned, expressions of interest or EOIs are different. These are not applications, so the rules relating to applications don't apply the same. So intention has no place in determining if someone should get a character waiver due to information provided with an EOI. Even if the assessment is taking place during the application stage itself, things that were provided with the EOI, the intention behind providing it has no factor when looking at the character waiver. However, with so many things with the sets of rules, there are exceptions, and these come through in the decisions we see from the IPT and that we've helped clients with. So these really are just the base rules. As I said, the application of law is often about exceptions, and this is no different. Now, we've covered very quickly a lot of information about character waivers for residence visas. We have barely scratched the surface, and pages of operational instructions, impacts from regulations, legislation, and hundreds of court decisions all the way to the Supreme Court on how these are to be handled will impact character issues and character waiver applications being made in the future. Character issues are often where a good application comes down to fail. If you have a character issue, we'd recommend you engage legal experts to assist, especially ones like McVeigh Fleming, who are experts in immigration law and handle a lot of character issues for clients. In the right hands, character issues can usually be resolved and or a character waiver can be gained, allowing for the visa to be granted. If you found this video of use to you, then please share it with others, leave a review for us on Google and the link in the description down below, and subscribe and click that bell icon to be notified about our future videos, one which will be out hopefully next week. Until then, kia kaha, stay safe.